Honourable Members, that brings to a close questions for oral answer. I have received a letter from the Honourable David Parker seeking to debate under Standing Order 380 the announcement by the Acting Attorney-General on 21 October 2010 that Justice Wilson will resign. In ruling on an application for an urgent debate, the Speaker has to determine not when an announcement was made, but when a particular case of recent occurrence occurs. The particular case must have arisen before the House meets to qualify for a debate. Justice Wilson's resignation does not take effect until 5 p.m. on 5 November 2010. Furthermore, it is a well-established rule that the House does not interfere with any question relating to the administration of justice or the conduct of a judge unless the matter is brought before the House by motion. And I refer members to Speaker's Ruling 32(3). Otherwise, it is unconstitutional to reflect on or speak disrespectfully of a judge, and there I refer members to Speaker's Ruling 32(4). This rule cannot be circumvented by allowing an urgent debate to be held. The application is therefore declined. Point of order, the Honourable David Parker.
Could I raise 2 points, sir? The first is, are you suggesting that this application would have been more properly made on the 5th of November rather than now? Because I would have thought if we had made it on the 5th of November, you would set it isn't a case of recent occurrence because the announcement had been made earlier. It's my first point of order. And the second point is, sir, I would have thought that it is quite within the powers of this House to try and protect the integrity of our institutions, and when a judge of our highest court retires or resigns under a cloud, that is a matter of public interest that ought to be able to be discussed, because we're actually protecting the of the courts and their reputation.
I'll hear the Honourable Trevor Mallard.
Sir, I think there are two other issues which this Parliament should properly debate without getting into the substance or reflecting on the judiciary, although in fact, as I've thought, there are probably three. The first, sir, is the role of the Acting Attorney-General in making a decision to spend nearly $1 million of taxpayers' funds.
The member now is getting into detail of the debate and not the issue of order.
No, sir, not at all. Sir, I think what I'm saying is that there is a government decision to do this, which has been announced. So the government decision to fund a retirement package was the subject of the announcement by the Honourable Judith Collins. So my question is about whether it's government responsibility or not, which I think you've gone to. There clearly has been. Sir, sir, it is in the letter that was given to you earlier this morning. So I think there are two other matters, and one of them I think it is fair goes not in a general way, but in a pretty specific way as to the integrity of our court system, with the indications that have been given over the weekend by the former Supreme Court Justice, or current still, but soon to be former Mr. Wilson, the Honourable Mr. The Wilson, I presume, that he had given all details to the Chief Justice. So and there is...
Order. The member's straying dangerously. Order. The member's straying dangerously now into actually saying under a point of order what he may wish to say in a debate, and we can't do that. I believe the member's points are raised in good faith. I've got no problem with that, and I fully accept the way the members have raised them. But in dealing with the first one raised by the Honourable David Parker, a case of recent occurrence, and I understand why the member has posed the question, but I would have to give him an assurance that this does not set such a precedent, that would be totally unacceptable were the Speaker to rule that an urgent debate couldn't be held in the House because a matter of recent occurrence hadn't actually occurred, and then to turn around and say, no, it was announced several days ago and therefore it's no longer a recent matter. That would be totally intolerable, and I want to give the member an assurance that I won't try and pull that kind of inconsistency for any member, because I think that would be totally unacceptable. The advice to me, though, is that a case of recent occurrence, in this case, the matter does refer to the proposed resignation of a judge, and that hasn't actually occurred. And certainly the reason why I gave the second part to my ruling was to give the member some assurance that applying again, though, wouldn't change the substance of my ruling, because it's in fact Section 23 of the Constitution Act 1986 that sets out that a judge can only be removed from office by the Sovereign or the Governor-General acting on behalf of the Sovereign, acting on an address from this House. And there is a proper procedure involving the Attorney-General for this House to resolve to make such an address. And it's my view that it would not be appropriate for us to try to in any way circumvent those proper procedures for dealing with a concern around judicial conduct, and to try and deal with it, to try and suggest that this House could to have a debate on the conduct of a judge just through the standing orders providing for an urgent debate, I think puts under grave threat the very important constitutional principle that separates the judiciary from this House. I'm conscious that the Honourable Trevor Mallard has raised the point of the importance of confidence in the judiciary and the importance for transparency. But of course this matter is not one that festers on. This matter is one that is to be resolved, because the Justice has announced his intention to resign on 5th of November. So it's a matter that has been or will be dealt with when he resigns. But it is my considered view, and I looked at this very seriously because I don't consider it to be a minor issue. I consider the matter is a matter of significance, and I wanted to make sure I gave it very careful thought. But I believe it wouldn't be appropriate for us to use the mechanism of an urgent debate to try and circumvent the procedures laid out in the Constitution Act and in our standing orders for dealing with issues of judicial conduct. The Honourable Trevor Mallard, further to the point of order.
Mr. Speaker, and I think there are two or three points that I would like to make, but first going to your specific point. So it's my understanding that Mr. Justice Wilson has resigned effective from a date in the future. So, sir, if there is a question about whether he has resigned or not, it is my understanding that he did as part of an agreement. I see some nodding from the other side of the House, and I think it is from the Acting Attorney General's statement. It was following an agreement which she was party to, and the question therefore is him having resigned, he can take no further part in our system, whether in fact this House can as a judge, from the bench, and he's made it clear that it's his feeling that he can't appear in court. But sir, this decision of his to resign was taken after an agreement with the Acting Attorney General as to a sum of money, roughly $1 million, which she announced. Sir, and the question then is, what rights does Parliament have with regard to someone who is no longer a judge, but the wisdom of the acting attorney making what is effectively a payout? Now, people can debate about whether it was...
Order. The member is... Order. No, point of order is being considered, and the member is now starting by way of a point of order to actually get into debating material. The Constitution Act and our Speaker's rulings are pretty clear on the only proper way to bring and this House unquestionably has a role under the Constitution Act, but the only proper way to bring such an issue before this House is by way of a notice of motion following certain other procedures that have been conducted. This particular case